Workplace harassment carries significant legal implications for both employers and employees. It is a serious issue that can lead to legal action, financial penalties, and reputational damage. Below is an overview of the legal implications of workplace harassment. 1. Violation of anti-discrimination laws. Workplace harassment often violates anti-discrimination laws, such as Title VII of the Civil Rights Act of 1964. Prohibits harassment based on race, color, religion, sex, or national origin. Equality Act 2010 protects against harassment related to age, disability, gender reassignment, race, religion, sex, and sexual orientation. Other jurisdictions. Many countries have similar laws prohibiting harassment in the workplace. Harassment can be considered a form of discrimination if it creates a hostile work environment or results in adverse employment decisions, e.g., firing, demotion. 2. Employer liability. Employers can be held legally responsible for harassment that occurs in the workplace, especially if they fail to take appropriate action. Key points include vicarious liability. Employers may be liable for harassment committed by supervisors or employees. Negligence. If an employer fails to prevent or address harassment, they may be found negligent. Duty of care. Employers have a legal obligation to provide a safe and harassment-free workplace. 3. Employee rights. Employees who experience harassment have legal rights, including filing a complaint. Employees can report harassment internally or to external agencies, e.g., Equal Employment Opportunity Commission in the U.S. Legal action. Employees may file lawsuits for damages, including compensation for emotional distress, lost wages, and punitive damages. Protection from retaliation. Employees are protected from retaliation for reporting harassment or participating in investigations. 4. Types of harassment with legal implications. Sexual harassment. Unwanted sexual advances, requests for sexual favors, or other verbal physical conduct of a sexual nature. Discriminatory harassment. Harassment based on protected characteristics, e.g., race, religion, gender, age. Bullying. Persistent mistreatment that creates a hostile work environment may not always be illegal unless tied to a protected characteristic. Retaliation. Punishing an employee for reporting harassment or participating in an investigation. 5. Consequences for employers. Lawsuits. Employers may face costly lawsuits and settlements. Fines and penalties. Regulatory bodies may impose fines for non-compliance with anti-harassment laws. Reputational damage. Public exposure of harassment cases can harm an organization's reputation. Loss of productivity. A hostile work environment can lead to decreased morale and productivity. 6. Preventive measures for employers. To mitigate legal risks, employers should implement clear anti-harassment policies, provide regular training on harassment prevention, establish a robust reporting and investigation process, take prompt and appropriate action to address complaints. 7. International considerations. In multinational organizations, harassment laws may vary by country. Employers must comply with local laws and regulations in each jurisdiction where they operate. Conclusion. Workplace harassment is not only unethical, but also illegal in most jurisdictions. Employers must take proactive steps to prevent harassment and address complaints promptly. Employees who experience harassment have legal recourse to protect their rights and seek justice. Failure to address workplace harassment can result in severe legal, financial, and reputational consequences for organizations. By Michael Obayelu.